Hi, good afternoon if you're on the East Coast, and good morning if you're out west. This is Aaron Lacey, and you're listening to Thompson Coburn webinars, part of the Higher Education webinar series for 2018-2019, which we're really delighted to bring. If you don't know us or Thompson Coburn, we're a law firm, and we've got locations around the country, but we're headquartered in St. Louis, and we're broadcasting today from sunny and sticky downtown St. Louis, right under the arch. I want to go ahead and jump in on the housekeeping. Some of you we know from our registrant list have been on many webinars with us before. You may notice we've got a new platform today, which we're also debuting and very excited to offer because we think it's got some real advantages. But that means the housekeeping has changed a little bit. So even if you've listened to webinars before with us or attended, please maybe turn a slightly more attentive ear here for the next few seconds so you don't miss anything. First of all, this webinar is, as almost all of our webinars are, CLE accredited. That's continuing legal education. So if you're a lawyer and you're listening in, you have an opportunity potentially to pick up CLE. It's approved for an hour of general CLE credit in California and Illinois and 1.2 hours of general CLE in the great state of Missouri. We've created polling questions, so this is a little different. In the past when we've done our webinars, folks looking to get CLE credit have looked for our secret words or our secret questions. Today what you're going to see on this new platform are polling questions throughout the presentation that will pop up and require a quick response. At the bottom of the screen, one of the other nice things about this new platform, we now have all of these wondrous widgets. They're all resizable and movable, so feel free to orient them to your preference. Two or three that I want to just highlight for you. First of all, if you have questions during the webcast, you'll see that there is a Q&A widget down there that you can click on. Please feel free to submit questions at any point in time, and we will plan to try to get to as many of them as we can at the end of the presentation. We set aside about 10 to 15 minutes to work to do that. A copy of today's deck was actually sent out was sent out before the presentation, and we're going to make an effort to send it out after as well. But we wanted you to know that it is currently available at the resource list widget. So that's a new innovation for us. You can now download the presentation right now if you like at the resource list widget. There's also a help widget. So if you have questions, technical issues during the presentation or otherwise, you can click on that one and see if we can get you an answer. Wonderfully, we have always provided these webinars for free, and we've always made sure they were on demand on our website following presentations. Historically, it's taken us a little while to make that happen. Just for Q&A process, it's 7 to 10 days. An on-demand version of this webcast will be available approximately 30 minutes after it's done and can be accessed using the same audience link that was sent to you earlier today. So we're very pleased that our on-demand feature now will be available quite rapidly following these webinars and presentations. With that, I just want to scooch over here to our next slide. So this presentation is about litigation in higher education. We also want to highlight here that we've got a whole series for you through the rest of the year. We've got another one coming up pretty soon in September, on September 12th. It's going to deal on mergers and acquisitions in higher ed, and we'll be sending out information about that. And then you'll see we've got lots of different topics that are going to be covered. They're all free. They're all CLE accredited. We encourage you to jump on throughout the year. We'd love for you to. I'll just highlight real quickly. I'm doing one in November, but I'll actually focus on the one in October, higher ed and November elections. A couple of our higher ed lobbyists from D.C. are going to be talking about the elections and the impact on higher education. I think that'll be, I think they'll all be good, but I think that one will be of particular interest given that we're in an election year. So one of the great things about this series is it's not just going to be me all the time, although I will do some of these presentations, and those of you who tune in I know have heard my voice on more than one occasion. But I'm very pleased that we're involving a number of our other partners that do work in higher ed. Today, the presentation is largely going to be managed by Bill Bay and Jeff Fink. So Bill is a partner in our litigation practice here at Thompson Coburn. He has been a litigator for many, many years. I count him as not only a colleague but also a friend. And in the last 5 to 10 years, Bill has gotten particularly involved in the higher education space and has defended multiple post-secondary institutions we've got here on the slide, and about 60 claims in lawsuits and arbitration. So a lot of experience dealing with institutions of all different types. Bill also, outside of sort of just the classic litigation context, does work for schools facing civil investigative demands, government investigations, regulatory actions, false claim act suits, et cetera. So we work together not only in the litigation context, but when folks sometimes have to deal with attorney generals of the U.S. Department of Education or some other agency that sometimes deals with institutions of higher ed. He has been recognized many times over for the quality of the services that he provides, and has been very involved historically and currently in the ABA, and also here in the state of Missouri is really involved in a number of statewide commissions. He is a guy that we are glad is a part of our firm as a general matter, and I'm just really delighted that he can be here today. So thank you for that, Bill. Equally delighted to introduce our other presenter, Jeff Fink, also a friend of mine and a colleague who has lots of experience in litigation, has worked very specifically with institutions of higher education over the years, again, in both the sort of classic litigation context as well as in front of agencies and various administrative actions. I'll actually highlight Jeff and I have been working quite a bit in recent years on matters involving the U.S. Department of Education. So Jeff is a guy who is trained as a litigator, but also has really developed a lot of expertise in managing program reviews with the U.S. Department of Ed and audit findings and appeals, and all of those Subpart G type processes for the regulatory nerds out there who know what I mean when I say Subpart G of the U.S. Department of Ed's regulations. So with those introductions having been done, and a huge thank you to both Bill and Jeff for kicking off the webinar series this season, I will turn it over to Bill to give you an overview of the presentation. Bill, it's all yours.
All right, thanks, Aaron. Thanks, everybody. We got a lot to cover here, but we're going to basically be in three categories. I know you have the deck slides either ahead of time or before you, but we're going to try to cover three broad areas: what gets schools in trouble, how schools can stay out of trouble, and how schools should handle student-related disputes. Jeff's going to cover the first two things, which I think are real important in trying to prevent the onset of a dispute. And then the third part we're going to take a look at is more not from the litigation perspective, but how do you in the field get ready when a dispute first comes to you. Obviously, we can talk about what lawyers do, but it's going to be more focused on what we should do pre-litigation or right when it begins from your perspective. So Jeff, go ahead and get us started.
Okay. Well, hello, everyone. The first topic today will be, what is it that gets schools in trouble with their students? And just to clarify at the outset, the focus today is going to be on disputes that arise directly between schools and the students. So we're not going to get into situations where there's disputes between students and the school is called in to intervene or decide the dispute, much like you'd have in a Title IX investigation. Instead, we're going to be talking about misrepresentations allegedly made by a school, broken promises, practices in marketing and enrollment, how you screen students, whether you change program requirements, your academic decisions that are adverse to students, stuff like that that's directly between the school and the student, and what kind of actions in those areas could get you into trouble. Now, historically, there wasn't a whole lot of litigation brought by students directly against schools. And that's because the schools have long enjoyed protection by what's called the education malpractice doctrine. And in the past, courts would say, look, we're not going to intervene in disputes between students and schools because basically the students are complaining about the quality of their education. Maybe their beef is, hey, I got bad teachers, or this is a bad program, this isn't what I was expecting, or I'm not learning anything. The stuff in this course isn't useful, it's not helpful at all, or the labs and the equipment, the tools that I'm using, it's not relevant to today's world. And courts in the past pretty much uniformly rejected those claims, saying, well, we're not going to get into that. We as courts, judges, are not capable. We're just not in that position to judge whether or not a school is doing a good job, whether it's providing a quality education. So what's happened, especially within the last decade, is students, and more likely the lawyers for students, have come up with ideas to get around the education malpractice doctrine, and they're attempting to reframe their complaints about education quality as fraud, maybe negligence, breach of contract, or if you're in a public school, a violation of constitutional rights. Now, the most common thing that comes up in student disputes nowadays is the student says, I was lied to, or the school didn't do what it told me it was going to do. They're unfulfilled promises. And this has been really prevalent in recent years, I think, for two reasons. One is the cost of education has skyrocketed, as we all know. And because of that, there's just a lot more at stake than there used to be. In the days when students could go to school for relatively cheaply, if it didn't work out, the student just went away and nothing was made about it. But now, if a student attends and things don't go well for the student might be saddled having paid $10,000, $20,000, $30,000, or might have student loans in that amount or more. And I think secondly, you're seeing claims about misrepresentation and broken promises because of the high level of competition between schools to get students. I mean, we've seen in recent years that the supply of educational services is starting to exceed the demand for those services. And so you have schools vigorously competing against each other to try to get students. And even within a school, you have programs within the school competing with each other to try to get students. And I think because of that fierce competition between schools, that's causing, and not at all schools by any means, but at some schools, you're getting some employees who might be saying things or making promises they shouldn't be making. Now, who is the person who's likely going to be asserting a student dispute? Well, it's not going to be probably not going to be your graduate who's out and got a good job and is successful and very happy. It's likely to be somebody who either doesn't graduate or graduates but can't really find a job in their field. They're the typical student who's going to come back and look for a scapegoat, somebody to blame for their situation, and the school is the number one choice. It's easy to blame the school. You can say the school didn't do what it said it was going to. And whether or not you made any misrepresentations or any promises, it's not hard for students to conceive of things and imagine things the schools might have said or did. I noticed in looking at some statistics, I saw an article yesterday, there were 24,000 federal fraud complaints filed with the United States Department of Education just in 2017 and through, I believe, April of this year. Now, most of these are in connection with trying to get federal loan discharges. So obviously, there's really no cost of filing that application, so it's easy for students to do it. But realistically, many of those complaints just as easily could have been asserted directly against schools in lawsuits or arbitrations. So we ought to be concerned that there are a lot of disgruntled students out there who think that they've been deceived or cheated by their schools. So let's talk about the misrepresentations and unfulfilled promises. And first, let's go through the types that are out there and that I've experienced. So Bill and I have been defending schools for the last 5-6 years in this area, and these are the more common types of issues that we've seen surface. I think by far the number one issue that will come up is about career outcomes and graduate employment. And the reason this is that it seems like every school out there nowadays is touting the career outcomes of their programs. It's not just limited to for-profit schools. I think virtually every university and school is doing it. My daughter just started school this fall at a public university, and I checked it out, and I said on the website that said 94% of the graduates were employed or pursuing additional degrees. So that was encouraging to me, and I sure hope it's true. It's also among professional schools, too, that especially law schools and medical schools, they are touting how their graduates are doing. And in the past, you never would have seen this. But nowadays, it seems to be a required element of any school's marketing. And there's nothing wrong with doing that. Given the cost of higher education, students understandably want to know what their job prospects are. But as a word of warning, this information needs to be as accurate as possible. Because if you give out inaccurate information about how your graduates are doing, if you're telling them that 95% of your graduates are placed in field and making good salaries when in fact only maybe half of them are, you're opening yourself up to liability for the disgruntled student who down the road graduates but can't find a job. And it may not even be the school's fault. But if the student thinks that the school has done something wrong or is looking for a scapegoat, that school could be that target. So let's give
Jeff,
some examples. Yes.
Jeff, this is Aaron, and I'll just add to that too briefly that, it's not, I mean, the easy example Jeff gave is, you've got a percentage out there and the percentage is dramatically wrong. But we've also seen government investigations, lawsuits, and complaints that have centered around not just the number, the actual percentage, but whether or not the methodology that was used to calculate that percentage was adequately disclosed, right? So it's one thing if you say you've got a 95% success rate, but are you really telling folks what a success rate is and how did you calculate that success rate, right? And if there are big qualifications on that, do you have an employment rate that only includes folks who are employed in field or out of field, et cetera? You can also find folks starting to create claims and assert complaints based on the idea, not just that the percentage is right or wrong, but also on the idea that, you didn't tell us enough about what this percentage meant or how it was conceived, and as a consequence, we were potentially misled.
Right, and in other claims, too, you'll have students say, wait a minute, you classified people as receiving in-field jobs when the job they got had absolutely nothing to do with the degree they received, or they could have gotten that job even without the degree. For example, if, say, they got a job at Best Buy as a sales associate. Well, school probably shouldn't say, well, by graduating from our computer science program, they're in an in-field job, because that student could have gotten that job at Best Buy even without going to school. So let's give some examples here of the kind of allegations you might face by students. Yeah, they might say, look, you, the school, you said you're going to locate a job for me upon graduation, or you're going to guarantee a job if I graduate from your program, or you'll guarantee I'll find a job within 6 months of graduating. Those are very dangerous representations, and schools typically, what we've seen, are pretty diligent in putting in their disclosures, their enrollment agreement, posting everywhere that, hey, we cannot guarantee you're going to find a job, and rightfully so, because no school can really guarantee anybody a job. They don't have control over how the student performs, how the student presents him or herself to employers. But even so, I mean, students still come back and they have this expectation that if I complete the school's program, I'm going to get a job, and they can still try to come back and say that you, the school, guaranteed I get a job. Another area I could get in trouble is if you say graduates of our program, they had a starting salary of a certain range, say $45,000 to $60,000. Well, that creates an expectation among the student that, hey, if I graduate, I'm going to get a job and I'm going to get in that range. And if that student ends up in a job that only pays $25,000 or $30,000, they're going to come back against the school if the school, in fact, made that representation. Another area of danger in this area is to give anecdotal evidence of jobs that your graduates have received, such as you say a big-time employer in your area has been employing a lot of the graduates there. That creates an expectation that, hey, if I graduate, I also can latch on with that company, when in fact they may or may not be true. Now, you can have oral representations made by people, but you also got to watch out for the written disclosures. A lot of schools will make written disclosures even in a paper given to the student, or a lot of them do it on websites. This is very common among, I notice, public universities and colleges, is they tout it right up front on their website. And you'll put up there, what percentage of your graduates got jobs. Some might say, here's a range of starting salaries that our graduates got. And you just have to be careful. That information needs to be undeniably accurate, so if questioned. And if a student comes back and questions it, they're going to dig down into the data and look at it. And they'll look for any possible basis to undermine it and challenge it and say that these figures are overstated, you lied to me. So you have to be careful about that. Another thing to be careful about, too, is to making future projections about what you think will be the job prospects in a field, how many job openings will be in a field. Seeing schools get in trouble for that, where they'll think, hey, this is a hot field. This is something you ought to go into because there's going to be an abundant supply of jobs, and then it turns out the market goes down. In a couple of years it takes the student to complete the program, and all of a sudden the jobs have dried up, and they look back and say, wait a minute, you told me there'd be a lot of jobs here, and then it turns out that there's not. So we mentioned how this was an issue for a lot of schools, but I'd just like to highlight that this was really a big issue in the last few years for law schools, of all things. And there were a lot of law schools, I'd say dozens of law schools, were sued because they were putting out information about how many of their graduates were getting jobs in different types of legal positions and what they were earning. And they were being sued all across the country for this, both profit schools, nonprofits. So far, the law schools have been very successful on that, and it may just be that the courts are unwilling to recognize claims by people in law school and say, come on, you're a law school graduate, you've got an advanced degree, a lot of education, you shouldn't be duped by any of this stuff, and we're just not going to recognize a claim in this regard. So let's talk about misrepresentations and broken promises. Let's move on. The next area that we see a lot of claims about of fraud, misrepresentation by schools involves the transferability of credits and or a degree to other schools. Now, this is frequently claimed by students after they drop out of one school and try to enroll in another school. Students are often shocked when they go to the next school and the next school says, well, I can't accept your credits from your old school. And it doesn't meet the students' expectations. They, for whatever reason, think that if I go to one school and have passed an English class, a science class, or whatever, that ought to transfer to every other school I want to go to in the future. So this is one area that you really need to be careful about. And I think the prudent course here is just to be upfront and tell students that we can't guarantee, we have no control over whether the credits you earn at our school or the degree you earn at our school can be used as a predicate for your education at another school. I noticed that a lot of public universities and colleges, the websites are all about what we'll take, what we'll transfer in, but I rarely see any disclosure on there about the possibility that credits earned at a public university may not transfer to every other school out in the country. And I think that's something that the schools ought to take into consideration and be aware of, given what students, their expectations and their belief that, hey, a credit earned at one school should be recognized universally at every other school. Another area where you can get into trouble with misrepresentations is with the financial obligations that you charge. You might have disclosures as to what the fees are and the tuition, but then there might be extra stuff out there that are necessary for the education that you're expecting the student to pay, but the student thinks is not aware of that. And so all of a sudden they get some huge bill for some item that they were never expecting. I noticed today there was an article about a online textbook at the University of Louisiana at Lafayette that they were charging $999 for an online textbook. And the reason for the charge was, in reality, they were trying to discourage the people from buying the online textbook. They wanted to buy the paper book at a much lower cost. The students were up in arms about that because a lot of them only liked using online textbooks. And they said, that's just outrageous. That charged almost $1,000 for a book. I expected to pay some amount for books, but this was way out of line. So if the actual costs far exceed your estimated cost that you've given to your students, you might have students coming back and complaining and saying, wait a minute, you breached your promise to me. You promised to give me education for this amount, and it's turning out to cost a lot more. Another area here that we need to be careful about, and I think most schools are good about this, is that what happens if you need to increase the tuition while the student's in the school? You're better off to make sure it's fully disclosed to the student that the tuition you're charging for their first year, that we, the school, have the right to increase it in future years. So if the student doesn't come back and say, well, wait a minute, you promised it would cost me $10,000 per year, and now you're raised the price to $12,000 or $13,000 per year. So you got to be careful in terms of what the expectations you create with the students are as to their financial obligations. Another area as to misrepresentation is in career services. And nowadays, the career services department is a very important part of most schools, given the expectation of students to get jobs. And so if you're promoting and touting how great your career services department is, well, you better make sure that it is, that it really is going to deliver the value that you've promised to students. Another issue where we've seen with misrepresentations and unfulfilled promises is with accreditation. A school could tell its students that it's accredited by a nationally recognized accreditor, and that may be an accurate statement, but then students later claim they were misled. They thought that accreditation was the same as regional accreditation of public universities. Or a school might say, we're working on obtaining accreditation of a certain kind of program. This is a really prevalent, and has happened a lot in recent years with nursing programs, because nursing programs, there seems to be a lot of value in obtaining programmatic accreditation of nursing programs. And what will happen, I've seen this in several cases, is the school will say, we're working on it, we think we're going to get it, it's going to happen. But then it doesn't happen for whatever reason by the time the student graduates, and the student's upset about that. And rightfully so, because some employers require that the student have graduated from a nursing program that has programmatic accreditation. So you just have to be very cautious when talking about accreditation and future efforts to get accreditation, that you don't create expectations among your students that you later can't fulfill. And then other areas of misrepresentation you might run into are the duration and cost of the program, graduation rates, and then lastly, we have on our slide about comparative advertising, which is pretty common nowadays, especially with school rankings. We've seen a lot of issues recently where schools have been manipulating data to try to bolster their rankings, whether it's in U.S. News and World Report or Forbes or other organizations that rank schools. I haven't seen a whole lot of litigation over this yet, but I could foresee in the future where a student sues a school for manipulating its ranking, saying, well, I went to your school because U.S. News ranked you as number 30, and then it turns out if you had reported the data accurately, you're really only ranked 100. So that's an area that schools need to be careful about, is with their school rankings and making sure they don't have any misrepresentation claims there. And then also in comparative advertising. That seems to be more prevalent today than in the past, where schools are comparing themselves to each other. And you've got to be careful here that whatever comparative advertising you do is that it's accurate and can be documented, because once again, students might come forward and say, hey, you misled me by saying you're better than your competitor school. Now, what are the potential sources of misrepresentations and unfulfilled promises? Well, it really can come from anywhere. It's anyone at your school is a representative of the school and could be accused of lying to the student or making a promise that the school no longer fulfilled. So this could be people in your marketing or advertising department. It could be admissions personnel. It could be financial aid personnel. It could be instructors. It could be the deans or other academic personnel. And in this regard, and I'm going to repeat on this theme later on, don't forget your third-party vendors. And they're out there marketing, trying to get students to come to your school. Are you watching them carefully to make sure that what they're saying on behalf of your school is true and accurate? Because whatever they say is going to be attributed to you, and you, the school, are responsible for the content that they're disseminating. So you've got to be careful in that regard. Now, where can the misrepresentations be found? Well, you might find them in oral statements. That's common, and that's the easiest thing for students to allege. And why is that? Because they can make up stuff. They can say, I talked to John Doe, and John Doe told me that if I graduated, I was guaranteed a job, making $50,000 a year. So you might have oral statements. But you might also find misrepresentations or promises in any of the pieces of paper that students have access to or are given. It might be the written disclosures. It might be an enrollment agreement, handbook, catalog. It could also be in marketing materials that are sent before the student even enrolls. And nowadays, given the prevalence of websites that every school has, you got to be careful with your website and make sure that everything on there is accurate, because your students could be looking all over for that. They might be seeing information on the website that conflicts with information they were told by admissions personnel or in disclosures or in other marketing materials. And then lastly, you might see misrepresentations in advertisements. And one thing that comes to mind is the billboards. I mean, it seems like you drive down the interstate nowadays, especially during the fall, about half the billboards are advertising schools. And you'd think, well, there's not much on the billboard that can get you in trouble, but there could be. If you're putting pictures on your billboard of stock photos of facilities, labs, classrooms, stuff like that you really don't have, are you creating a false impression among students? And they come to your school and say, wait a minute, where's that lab that I saw that's on that billboard? Where's that building? So you got to be careful there too to make sure that you're not putting out anything that gives a false impression to students. Let's talk about now the marketing enrollment practices. This is another area where you can get into trouble. And here we got to be careful. This is an area that's probably becoming more and more prevalent as the amount of information, the amount of contacts has greatly increased to students. I mean, we're getting now a very competitive market for students, and students are flooded with mailings and phone calls. And I know in the case of my children, beginning in their sophomore year in high school, it seemed like right after they took the any kind of exam, or somehow the schools get the information, you get multiple mailings from the same school. You get multiple phone calls from the same school, people trying to get you to enroll there. And so there might be repeated telephone calls, you have text messages, emails to prospective students. And while the volume of communications in itself is not bad, it's an area that students cite when they bring suits against schools and say, wait a minute, you're harassing me. You wouldn't let me go. And you wouldn't give up until I said yes to coming to your school. Areas you can also get in trouble too is if you try to get students to attend by appealing to their emotions. Or if you pressure them or rush them to enroll. Now, standing alone, these practices shouldn't get a school into trouble. I mean, by themselves, they're not a big deal. But what happens is students use these practices to bolster their claims that you, the school, have made misrepresentations or broken your promises to them. They'll do is say, and what they try to do is they try to create credibility for their story by saying, I came into the school, and I had to sign, I was rushed to enroll within an hour. And then they say, and by the way, they got me to do it because they made promises that I'd get a job, that my credits could transfer to any school, the program would be accredited. That's why you got to be careful in how you market and in the enrollment practices with students to make sure you're not rushing them through, that you're not pressuring them, that you're giving them time to review documents and to make a reasoned decision. Another area that you can get into trouble, and I find to be a rather unique and novel area, is students claim that there's inadequate screening of them and that you, the school, allowed unqualified persons to enroll because the student lacked the academic skills, they didn't have the background to succeed in your program. And this goes far beyond what's in the federal regulations about certifying student eligibility for loans. As you probably are aware, in federal regulations, if you participate in Title IV programs, you cannot certify a student if there's some kind of physical or mental condition, age, or criminal record or other reason that would prevent them from ever getting a job in their occupation for which they're training at your school. Now, students claim it.
Jeff, this is Aaron, I'm a terrible interrupter. But I'll actually take a guess that a lot of the folks on the line may not be aware of this provision. So my guess is most of you who have familiarity with federal financial aid, and to the folks who are general counsels or directors or administrators who may not interface with federal financial aid as regularly, there's a concept called false certification discharge. And basically the idea is if a school does certain things when it's certifying a loan, those things constitute, quote, a false certification, and a student subsequently can seek to have the loans discharged. A lot of people aren't aware, in my experience, of this provision, which basically says if you certify a student for a loan and at the time you were aware that, quote, the eligibility of a student because of physical or mental condition, age, criminal record, or other reason would not meet the requirements for employment under state law. The department has always interpreted this, though it's not written here, as being under a state law requirement. Then they could seek a false certification discharge. That's kind of tricky business because you may not be able to inquire about disability or mental condition at the time of admission because of various state and federal discrimination type laws, but at the time that you are certifying a loan, you should be aware that if this person is looking to go into a profession that's regulated by the state and you certify that loan and they don't have the physical or mental capacity to obtain that certification due to that disability, you could be on the hook for a false certification discharge. You don't see this very often because students don't necessarily know about it either, but you should be aware that that's out there. And as an aside from this entire presentation, you ought to think about your processes and whether or not you are giving any consideration to this, particularly, again, in programs that lead to professional licensure by the state. Sorry, Jeff.
No, I appreciate the input, Aaron. And as you can see, the standard itself is rather vague, because how are you supposed to know if a student's physical or mental condition will prevent them from being able to get a job in their field? And so, like I said, this is kind of a unique, novel claim by students, but ultimately what they're saying is you should not have allowed me in. You should not have given me the opportunity to take your program, try to benefit from your program. And so I don't foresee courts really finding much sympathy for this position, but just to alert you, students are out there now saying after the fact, well, I should never have been allowed in the program in the first place. Another area that can get schools in trouble is when they change program requirements midstream while a student's already enrolled and going through the program. You might have changes to the curriculum. You might have changes to grading policies or to required exams or graduation requirements. We've seen this in cases involving a nursing program where a school changed the passing grade for classes from a minimum of a C to a B, and then also said if you got 2 grades below a B, you're going to be dismissed from the nursing program. The school had good intentions for this because they had statistics showing that students, if they were getting B or better grades in their classes, they were more likely to pass the nursing licensing exam, which was, after all, the ultimate goal of the nursing program. But you had students complain and said, wait a minute, if you had told me I had to get a B or better in every class, I never would have came here. I only came here because I thought I could skate by with a C grade. So there's the problem there if you change in midstream on students as to grading. Same with required exams or graduation requirements. This case we had involving a nursing program, they implemented an exit exam. It was a standardized test offered by a nursing service. And the exit exam, and if you passed it, you're a really good chance you were going to pass the nursing licensing exam. Well, students complained. They couldn't pass this exit exam, and therefore they couldn't graduate, and they weren't allowed to sit for the nursing licensing exam. And they complained, said, wait a minute, you didn't tell me I was going to have to pass this. So the problem you can face is if you change requirements in midstream. So that's something to be aware of. And then lastly, for today in our presentation about what gets schools in trouble, we'll talk a little bit about adverse academic decisions, suspensions, and dismissals, and how you can get in trouble if these are arbitrary. Now, schools typically have a lot of deference in how they treat students in academic decisions. The courts just do not want to get involved with this, and they're going to defer to schools as long as what you do is in good faith and in accordance with your processes. Where you'll get in trouble is if you act arbitrarily or capriciously or in bad faith. And some ways that you could get in trouble, and the number one way I think I've seen is if you fail to comply with your policies. If you have written policies in place governing academic discipline, you raise an issue with the student, and then for whatever reason people aren't aware of the policies, or they forget about them, or they try to change them on the fly, that among most anything will get the school in trouble with the student. You could also get in trouble and have an arbitrary decision if you did an inadequate investigation of the facts, if you don't give the student a chance to respond, and a meaningful chance to respond, not just show up and tell your side of the story, but let the student know in advance, here's what we think's happened, here are the charges against you. Take some time, think about it, and what do you say about it? You also need to make sure you have an unbiased decision maker. And then lastly, you want to make sure that your decisions, to the extent possible, are consistent among similarly situated students, because once you start doing one thing for one student and a different thing for somebody else who's in the same shoes, you're going to get claims of discrimination or inconsistency, and you're acting arbitrarily, and that can get you into trouble. So the types of claims that you'll typically see in litigation or arbitration, I mean, typically if it's a misrepresentation, you're going to get a fraud claim, maybe a negligent misrepresentation claim. You'll also likely get something under a state consumer protection statute. Now, those vary from state to state. In some states, the students may have no claim, and it may depend, too, on whether the state thinks that the student is buying the school services for, quote, personal purposes, or whether they're doing it to try to make money. And courts kind of have a difficult time dividing that line. Some states will say, well, wait a minute, education is inherently to better the person. It's always for personal purposes. Other states, the courts may say, well, no, you're really doing this to make money. So it's really not for personal purposes. Therefore, our consumer protection statute doesn't take care of you. So if you have claims of misrepresentation, you're typically going to be for fraud or breach of a consumer protection statute. You might get a claim of negligence. You might get claims of breach of contract. And that happens especially with public universities and colleges or with breach of contract. The reason being is a lot of them have protection from tort-type claims, their sovereign immunity, but they don't have immunity for breach of contract claims. And then you might also have constitutional claims. The students might say, you, the public school, deprived me of due process. You violated my constitutional rights. And what kind of damages could you be liable for? Well, damages can be substantial. I mean, you have a refund of tuition and expenses, which in itself doesn't seem to be that bad. I mean, that's a relatively modest amount. You might have to reimburse student loans, also maybe not too bad. The real problem you can get is with punitive damages is if the jury or the court finds that you engaged in egregious conduct and really hurt a student, who can often be a sympathetic figure, you might award punitive damages. And then not up here, you might also be faced with attorney's fees too, being liable for the student's attorney's fees. So I'm just going to go through a few case examples, and then we'll move on to our next topic. I mean, you see in the press all the time about the cases against for-profit schools. I mean, there have been verdicts against for-profit schools for misrepresentation where you might get $25,000, $30,000 in actual damages, which doesn't seem that bad, but then you get multi-million-dollar punitive damages and big amounts for attorney's fees. But nonprofit schools and universities can also face significant liability. There was a case from last year in Nebraska where a nonprofit health science college, it was sued by a student in the nurse anesthesia program for breach of contract. The college had placed her on clinical probation for alleged misconduct and then administratively withdrew her from the program, so basically kicked her out. Case went to trial, jury verdict. And this is against a nonprofit health science college in Nebraska. Jury verdict of $1 million. Now, that got overturned on appeal, and there's going to be a new trial, but the new trial, you could have a smaller, greater verdict or no verdict. But just to show you that the amount at stake can be very significant. And then another case, a year ago, this is in Ohio, that a public university, and this had to do with its nursing program. It had to stand trial because it was alleged the university had promised that its nursing program would be accredited before the first student graduated, and that didn't happen. And then another case, and this involves the University of California back in 2007, where the university got in trouble because it breached its contract with students by raising its professional education fees. The university thought it could do so, even though it said on its website and in its catalogs that it wouldn't do so, wouldn't raise the fees, tried to do so, and then it got sued, and the court said you can't do it. So, and even we're talking about for-profit schools, nonprofits, but even the most prominent schools have faced significant liability as students. We've had Ivy League schools and prominent schools in Chicago get in trouble because they didn't follow their student handbook in administering academic decisions against students. So the lesson here and the takeaway is that, all schools, whether you're for-profit, nonprofit, prominent, whatever, you need to take the risk as a student dispute seriously. They can be very costly. And next I'm going to talk about what schools can do to stay out of trouble. But before that, we have our first poll question of the day for those of you seeking CLE credit. That slide should appear on your computer screen, and you are asked simply to click the choice next to the word soul below. And we'll give you a few minutes or a few seconds to do that, and then we will move on. All right, now let's go back, and our second topic, our presentation today, is we told you how schools can get into trouble. So now how can schools stay out of trouble? And I think the number one thing that schools can do is control content of marketing activities. And by that I mean you can control the content of all marketing activities regardless of where it comes from. You need to keep a close watch and a tight control on all of it because any of it can bite you. You got to watch the oral communications by school personnel, whether they're in admissions, financial aid, whether they're marketing, academic. Any communication by anybody affiliated with your school could land you in trouble. You got to keep tight control over your marketing materials and your advertising. What is it your prospective students see? I mean, maintaining control over that. Do we know what's going on? The website, given how prevalent your website is nowadays, that the information on that must be kept up to date. You cannot have information that's inaccurate, that contradicts what's in your catalogs or in your enrollment agreements or any of your policies. Very important that the website be up to date. And I mentioned this earlier, but you really need to keep close tabs on your third-party vendors, which I know are very common nowadays in marketing school services to prospective students. You should watch what they're doing. You should see what they're doing. You should review the stuff they're sending out, and you should have an agreement with them to make sure that in case something goes amiss, that you're protected. You should have audit rights. You should make sure that the third-party vendors are reporting to you. And lastly, probably most importantly, you should make sure that you have indemnification by the third-party vendor in case they did something wrong. Now, I won't go through all the misrepresentations we talked about before in terms of content, but probably the three biggest ones are the career outcomes, transfer of credits, and accreditation issues. And with career outcomes, like I said, it's common for schools to report the outcomes of the graduates of the program, but just be careful. Just no fudging of the numbers, and make sure that when you report a graduate is placed in the field of that program, that it's justifiable and you're not embarrassed to stand up in court and say, yeah, that student graduated from our program, and that job he got he was able to get that because of the program that we offered. On accreditation, be careful. Don't make promises about stuff that's going to happen in the future that you might not be able to fulfill. You don't want to create expectations among your students that something's going to happen when in fact there's a chance that it might not happen. And no matter how careful you are in saying it, like we're working on it, we think it's going to happen, you can almost guarantee the student is going to translate that into it's going to happen, and then if it doesn't, they're going to be upset with you. And then with transfer of credits, I think it would be wise for every school just to say, I can't guarantee that our credits are going to transfer. It's up to the receiving institution. If you think you're going to go to another school, you better check now before you start here whether they're going to accept our credits, so that you don't have any disappointed students in the future who claim that they weren't told, hey, my credits weren't, if I'd have known this, I never would have came to your school. Now, in terms of keeping your school employees out of trouble and not making misrepresentations, the training and the written policies for them are crucial. And what you need to do, you've got to have the training and you need the written policies as to what they can and cannot say to students and prospective students. And you really got to train them on the various areas that you foresee you could get in trouble on, such as career outcomes, accreditation, transfer of credits. Make sure that they know in advance what it is they can and cannot say. Have them sign acknowledgments, recognizing, yes, I've been told what I can and cannot say to students. Repeat the training and the written policies from time to time so that it's fresh in their mind. The value of all of this is that it helps schools and its employees rebut allegations by students. Because what's going to happen is that if you have allegations by students against your current employees, realistically your current employees are not going to remember what they said to a particular student. And the best they're going to be able to do is to be able to say, well, there's no way I would have told them that we guaranteed them a job or that their credits were transferred and stuff like that. The reason they're able to testify to that, though, and it bolsters their credibility, is if there was training that they acknowledged receiving and there are written policies in place by the school saying they couldn't say those things, because then your current employees will say, well, obviously I was going to act in compliance with the training I received and the written policies of the school. The value of the training and written policies also can be crucial when you have former employees. Your former employees may not be so cooperative when a student sues and says, hey, your former employee lied to me. Former employee may have moved across the country, may not like you anymore, and may not want to be willing to cooperate. And in which case, you're going to be relying primarily on the training and written policy to say, well, we trained him not to say this. He agreed he wouldn't say this. We had written policies in place. And because of that, we believe that there's no way that we would have told the student what he's claiming we said. So the training and the written policies can be very, very crucial. Another area another way you as a school can stay out of trouble is to be sure to use written signed disclosures with students. And in this regard, you can do a 1 or 2 page disclosure or multiple disclosures But we should do is address the most common types of alleged misrepresentations or unfulfilled promises the school might face. You might want to have a disclosure that says, hey, we don't guarantee you a job or any particular salary. Your credits, your degree here may not transfer to other schools. Here are the financial responsibilities when you come to here, and by the way, these are subject to change. And as regards to any rules, policies, and course requirements, you ought to tell the student that they're subject to change from time to time as need be. And then when you use a disclosure like that, be sure the student has an opportunity to review the disclosures before they register or pay anything. And you want to get their signature on there because that's good proof that they saw the disclosure before they started at your school. And be sure to give them time. I mean, an accusation made by a lot of students is that, yeah, there are these disclosures, but the disclosures were just rushed to me. I just signed 50 pieces of paper, and the admissions representative just kept presenting one after another and told me to sign on the dotted line. Be sure the student has time to look at the disclosures, and that'll give you a lot better chance in court to show and to rebut allegations that you've lied to the student. But in that regard on disclosures, this is pretty common, and we've counseled clients to do this, is to use a one-page pre-admission or pre-enrollment checklist. The nice thing about it is if you have a lot of disclosures that are found in many different documents, if you have a nice summary of it, of the key stuff, it makes it really hard for the student to come back and say that they weren't told something when it's there on a one-page piece of paper that they reviewed and signed. Now, just to be clear, just because you have these kind of disclosures, it's not going to immunize you from misrepresentations or broken promise claims, but they are powerful evidence to rebut a student's claim against a school. And I've seen, there's a recent case out of Ohio where the court dismissed the student's claims because he had signed acknowledgments saying, I received a school catalog and I received other disclosures, basically directly contradicting what the student said had been misrepresented to him. So these disclosures, these checklists can be very useful in helping schools stay out of trouble. Another way to stay out of trouble is to have a well-defined internal grievance process. And the reason for this is that this is a way, if a student comes in and is complaining, you can force the student to try to work with you to resolve the grievance before he can bring a claim. A lot of courts will enforce the internal grievance process as a prerequisite before allowing a student to sue. Now, those processes should be clearly defined in the enrollment agreement, your student handbook, catalog on your website, and be sure that the student's made aware of the processes at the time of enrollment. Another way to stay out of trouble is to make sure that whatever it is amounts to your contract, whether it's enrollment agreements, your school catalogs, your student handbooks, make sure that they're clearly defined, that everything is spelled out in there that you want spelled out. States usually treat the relationship between a school and its students as contractual, and that's understandable. The school's offered to provide an education for a price, and the students agreed to pay that price and agree by the school's policies. The problem you see at a lot of schools, and especially among public universities and colleges, is that what is really the contract? You don't really go in signing an enrollment agreement or a contract, and so it created a little bit of a problem for courts. And so what they've done is say, well, what's the reasonable expectation? What would a student reasonably expect to be part of his or her contract with the school when they enrolled here? Problem, if you don't spell it out, is that what you have is after the fact, well, what are the reasonable expectations? And what you thought was reasonable and what the student thinks is reasonable, obviously are going to diverge, otherwise you wouldn't have a lawsuit. And then by not having the stuff defined in a written contract or spelled out somewhere, you're leaving it up to somebody after the fact to judge what was reasonable in terms of your behavior. So I think it's safer to spell out the terms of the contract. I mean, basic things like the tuition and costs, the grounds for various types of academic decisions, whether you're incorporating school catalogs and student handbooks. If you have a written contract document, you make sure you incorporate that if you want that to be a part of the terms governing the student's attendance. Provisions that can be changed. If you're going to reserve your right to change stuff, make sure that's in there. And then it doesn't hurt to repeat key disclosures within the contract documents, such as there's no guarantee of a job, your credits may not transfer. Stuff like that, it doesn't hurt to say it over and over again. Because like I said, those are the number one area where you can be sued by students, and the more you say it to them, the less chance they have of being able to present that type of claim. And then lastly, before I turn it over to Bill, just to throw out here, if you're looking to minimize risk, consider using arbitration provisions and class action waivers. The Federal Arbitration Act is a very strong pro-arbitration federal statute. You may have heard, the U.S. Supreme Court has been very pro-arbitration in the last 10, 15 years. And many schools have taken advantage of the Arbitration Act, and they include in their enrollment agreement a requirement that students arbitrate any disputes they might have with their school. Now, this used to be pretty much limited to for-profit schools, but in recent years we've seen a lot of nonprofit schools are also using arbitration agreements. There's a lot of advantages to using it. And it's typically cheaper and faster than litigation. It's simpler in terms of procedure and evidentiary rules, more flexible as discovery and hearings, which can be a big benefit to avoid disruption to your employees. You can typically keep your disputes confidential so they don't spread like wildfire among your student body. And I get most importantly from a school's perspective is you can avoid class actions and limit your risk. And although not on the slide here, another consideration here is that with a class action, if you're using an arbitration provision, you're going to have usually one person, a lawyer, arbitrating your dispute. And typically an arbitrator, even if he finds in favor of the student, is much more likely to give a much lower award than if you're facing a jury. Typically the big awards against schools have almost always involved juries. And so you can avoid that risk. You can avoid class actions by using arbitration. Now, the Department of Education has taken changing views on arbitration, and I'll just go through this quickly. As you may know, during the Obama administration, the Department of Education tried to ban pre-dispute arbitration agreements. This was changed under the Trump administration. So now schools can still use pre-dispute arbitration agreements with students, but the Trump administration and its new rule is requiring schools to provide more disclosure. You got to put it on your website, and during entrance counseling with your students, you got to basically tell them and be upfront with them that, hey, if you got a dispute with us, you're going to have to arbitrate. And then lastly on this point is that the U.S. Supreme Court recently, a few months ago, issued a decision that pretty much guarantees that if you use an arbitration provision with students, that it's going to be upheld, and you can do that. So before I turn it over to Bill, I am going to let you know we have another poll question up here, and I'll give you a few minutes to complete it. And here you are asked to click the choice next to the word respect below. So I'll give you a few seconds to that. We'll turn it over to Bill, and Bill will be talking soon about how schools should handle student-related disputes once they arise.
And Jeff, I'll jump in just quickly and add a couple of quick thoughts for folks. The first is just in terms of time, we do realize it's coming up on top of the hour. We're going to go ahead and proceed through this at the normal clip because remember, this is available on demand, hopefully within an hour following, if not less, following the presentation. So we want to make sure to get all the content in and to answer the questions that folks post. If you need to drop off, we totally understand that. Our goal was an hour, but we want to make sure to get all this important content in. And remember, you can come back for free at a later point today or tomorrow or at your convenience and listen to the last section. Of course, you are most encouraged to stay on and listen now. The one comment I will make is if you are in this for the CLE and you can hang in there, that would be the right idea for CLE purposes. The other thing I want to mention just as a substantive comment, Jeff made the point earlier that we're seeing more nonprofits using arbitration, pre-dispute arbitration clauses, class action waivers, and some of you may have raised your eyebrows, particularly if you work for a public or private nonprofit institution. And I want to clarify, as you know, traditional institutions of higher ed on the nonprofit side typically do not have enrollment agreements, but particularly at large, sophisticated, complex institutions, it is our experience that there are many agreements that students are signing with institutions that may be related to their access to student athletic facilities. It may be related to their participation in athletic events or student clubs. It may have to do with their use of housing or a parking complex. And it's in those agreements that we increasingly see the use of pre-dispute arbitration agreements and class action waivers. In fact, many private, nonprofit, and public institutions have actually had those agreements in place, or those clauses in place in those agreements for many years. So while it is not the case that they typically use enrollment agreements, for the lawyerly types and the general counsels out there who know about all those other little agreements that exist, they'll probably recognize and be aware that there are pre-dispute arbitration and class action waivers floating around in a number of agreements at their institutions. So with that, Mr. Bay, I turn it to you.
Okay. Well, I thought we'd take the next 15, 20 minutes talking about how schools should handle student-related disputes. And I'm trying to try to be practical and not talk about cases where you already have outside counsel helping. That's a different kind of animal. You may have disputes that get there, but this is really for institutions either that may have in-house counsel that and talk about how they're going to practically do some things, but sometimes many institutions don't have in-house counsel. So let's talk just a bit about how you handle student-related disputes. It may seem odd to start with the obvious, but you cannot handle what you don't know. The reality is you have lawsuits that are served, sometimes that don't get to the people that need to have them. More importantly, there are disputes that a department or individual may have with students that somebody tries to handle on their own. If you want to handle disputes, you have to create a mechanism to know about them. And so what we try to do is advise our clients to create charts so you can be sure you have a handle on what disputes are before you. And I've got some examples here. It's a simple thing, but I think it works. And there are 4 reasons why I think these are useful. Number 1, it creates a real reporting culture and practice that all disputes, complaints, and litigation get centralized in one place. And you know whether they are either student complaints, agency disputes, or lawsuits. Number 2, it allows you to monitor the progress of the response. Agencies can be very slow to act. A chart like this ensures that things stay on your radar screen. Number 3, it permits you to look at patterns. I'm a big believer in looking at data and patterns. You can identify problem areas and processes that need to be addressed from a management perspective. A look at 3 to 5 years of disputes can be very helpful in improving parts of your school that are taking an inordinate amount of time to deal with certain challenges and deal with complaints. And 4th, of course, it practically allows you to get information for reporting to board, management, insurance, accreditors, state higher education agencies, and other people that need to have information. Now, once you know there's a dispute, what should you do? A school's actions when it first learns about a student dispute are critical. A student dispute can easily mushroom into various other things you don't want to see. You can see copycat disputes raised by other students who have communicated with people through social media. You can have state attorney general investigations that can be based on just one complaint to them, sometimes more complaints. You can have accreditation issues. It is almost always in the school's best interest to resolve student disputes as quickly as possible. And there are 2 practical reasons which you probably know about. Number 1, litigation is expensive. If you can avoid it reasonably, you want to do so. And number 2 is negative publicity, regardless of the merits of the dispute, is never helpful. So what are the things you should do? I know the first one is check your school's processes and procedures and follow them. It sounds too simple, but the most important thing is to follow the processes and procedures you have in place already. Invoke the school's internal grievance process. Make sure it's followed. If you have an arbitration provision, and many of you do not, invoke it if it's appropriate. And if you have those kinds of things, make sure that timely paid fees and you're following the rules. If a student has filed a lawsuit, even though she has agreed to arbitration, you've got to invoke that. You can't just litigate and then decide I want to do arbitration. Second is you got to get to know the deadlines. Every agency and every court has different deadlines, procedures, and requirements. Your lawyer will help you with the court deadlines, but you're frequently going to be dealing with the agency deadlines. They're all different. You want to check with each agency for what they want, the form they want, and when they want it. Obviously, you have also HIPAA and FERPA rules. I'm not going to get into those because you know them only too well, but also, be mindful of those as you respond. Number 3 is really develop a plan tailored to address each complaint. It is very important to recognize one size doesn't fit all. Make sure your investigation plan fits the complaint. That requires you to understand the complaint a bit before starting. Not every complaint merits a full-blown investigation. Don't go overboard. But also, don't be guilty of not spending enough time on the front end to make sure you understand the complaint and the potential consequences. Don't forget, and I should say, read between the lines of what is written. Also, don't forget about insurance and reporting. You got to get with your insurance broker to see what needs to be done if that's an issue, and frequently it is. But the most important thing is to be proactive and work the problem. That, I think, is the secret to success for all student complaints. Don't put it off. And I am reminded of one of my favorite movies, Apollo 13. The capsule's in distress. It may not return to Earth safely. Its heat shield is damaged. It's running out of oxygen. It's getting very cold. Panic is setting in on the movie at NASA. And Ed Harris is there calming them down and saying, wake everybody up. We need to work the problem. And no matter how serious or insignificant, you need to work the problem. If you're going to successfully resolve disputes and complaints, start with the very first day that you get it. So what is it you should do? I think fact-finding is really important. Be an effective detective. I was going to say channel your inner detective, be a Batman, but don't do the violence and moodiness, never appropriate. But you want to start with really, here's kind of a checklist, a paper trail checklist. You want to start with documents, email, data, and social media. You need to preserve documents, you need to preserve emails, and you need to preserve electronic data that the school has control over, and data that the school reasonably knows or can foresee may be relevant to a claim or defense that could be asserted in a dispute. This is an important legal requirement. Failure to comply with a duty can get you into trouble in court or in any kind of proceeding. It's always difficult to predict with complete accuracy what may be deemed relevant or sought in discovery, but the safest course, and I strongly suggest the safe course, is to err on the side of preservation of documents and all data with respect to all materials related to the student or the dispute. Most of the time, but not always, the documents will help your position, so you want to hold on to those. And as I put in here before we get to the checklist, make sure you're digging in all the right places. And I think that's really the key item that you want to do at the beginning. It saves you a heartache with lawyers later and causing you more expense with counsel. And again, I hark back to another one of my favorite movies in the iconic film Raiders of the Lost Ark. Harrison Ford and the Nazis are racing to find the map room to locate the Lost Ark. The Nazis are ahead. The great news for Indiana Jones, the bad guys were digging in the wrong place because they had incomplete information. They only had information from one side of the medallion. Don't succumb to the perils of incomplete information. Getting all of it is crucial if you're going to make the best decisions. So what should you do on a checklist? I think really 4 things here I jotted down. First of all, concentrate on where you're going to look, the physical locations. You got to obtain all the available documents and data regarding the student, but the places to search are the campus, the school's headquarters, if it has multiple campuses, and the school's IT department. That's the first place to start physically. Then what people should you contact? Well, the student's instructors, the academic advisor, the dean, the program head, the admissions personnel who dealt with the student, financial aid personnel who dealt with the student, career services counseling personnel who dealt with the student, and other administrators who may have had some interaction with the student. Now, what kind of files do you want? Well, of course, it all depends on the dispute. But I think the types of records you want to get are the student's academic file, the financial aid file, the career services file, instructor files concerning the student, program-specific files. For example, if you have a nursing program, there's going to be separate program-specific files there. Emails with the student or that mention the student. I mean, that's your first instinct, but this is, I think, broader to get all of this right now. I think it's also important to generate screenshots of certain kinds of data because they're vital, because the people who are interacting often with the student only see screenshots. So I think preserving that now is very helpful and helps you tell the story. You obviously want all documents about the academic performance, the attendance, if there's course surveys, and the other course surveys that other students did who were in the same course as the complaining student. attendance documents, if there's any advising contents, and the student's activity in the school's computer systems. I think one of the first calls you want to make a dispute is to get with the school's IT department to make sure that you have the right data. And you may have a set procedure. I think it's more useful to have a set procedure you follow. Social media, the last thing, review the student's social media postings that are publicly available. Those are fair game. Don't make a friend request to gain access, okay? So, now, what about talking to people? Well, you want to talk to people that dealt with a student. It's not as easy to do this as you think. People forget what they did, and sometimes they want to forget they ever had interaction with a student or a situation that's resulted in a dispute. It's crucial for you to review documents to determine who was involved. And once you do, you want to learn what they know about the student and the student's allegation. I think it's important early on to evaluate their strength as a witness. Do you believe them? Are they the representative of the school and its values and who you want to tell your story? Sometimes you don't have choices, but always remember they will be telling your story. Now, when you're dealing with current and former employees, how do you do it practically? Well, you go over the basic allegations. I think you ought to provide them the important written documents and anything their name is on. I think it's helpful to have key documents in chronological order. It helps them remember and keep everything in order. Make sure they've done their homework and refresh their memory as to what happened. I think it's important to have witnesses who can answer questions. Fact finders like judges and arbitrators and jurors expect schools to have answers to reasonable questions. I don't prefer witnesses to say, I don't know or I don't remember over and over and over again. I like to help them get up to speed by providing documents for review and time to prepare. Remember that telling you what happened in a dispute is not most employees' favorite activity of the day. So you've got to give them time to get up to speed by reviewing documents. I think it's important to advise them to not talk about the dispute with anyone unless instructed to do so, and have them alert you or alert appropriate school officials if anyone outside the school contacts them about the dispute. Now, lots of times you're going to be dealing with former employees. It's a little bit different. You have to be more careful with them. You can advise them that they are not required to discuss the case with others, but you can't prohibit them from doing so. The other thing, I think, third thing here out of the 5 I had listed, is ask difficult questions. Don't be afraid to do so. If you don't, somebody else will do so in a setting you don't want, and you may be surprised, and usually not in a good way. The other thing is, I think it's important to understand why people act in a certain way. That's why it's often important for witnesses to use a chronology of documents that you've prepared with the screenshots. It puts them back in the time period of when this dispute first arose, and so you get the benefit of their thinking as to why certain actions were taken. Now, should you involve a lawyer? Sometimes you can tell a dispute will be bad and counsel needs to be involved from the outset, but most of the time it's really not necessary. With our clients, they frequently investigate, forward a draft response to an agency, and ask us to review it. That's okay. Sometimes we review the file for a sanity check. Both are okay and perfectly fine ways to review things. Now, if there's a risk that current or former school employees might be sued along with the school, you got to be extra careful. That's often done by students' lawyers to keep a case in state court. You can have joint representation of the school and employees. It's usually advantageous to the school. It encourages cooperation by the employees, especially former employees. But if you do that, a joint engagement letter should be prepared and reviewed and signed by the school and the employees. You need to be careful of conflicts, and you need to be clear that the school's counsel will continue to represent the school even if the counsel must stop representing the employee. So don't be worried if such a concept is raised by your lawyer. We're not going to go into all the nuances, but just so it's not a foreign concept to you if it comes up. Now, what's the next thing is, once you've done all the fact-finding, I think it's critical to develop a chronology and narrative based on the facts and interviews. Understand the story and who will tell it. This is probably the most important thing. You have a narrative and a story to tell about every dispute. Who's going to tell it? If you have no witnesses, it's hard to prevail. You got to be comprehensive in your chronology. Insignificant things on a Monday can be crucial by Thursday. The chronology should have reference to each document and what each witness said, so that anybody reading it later can say, I get exactly where all this came from. If there are inconsistencies or big questions, make a note. There is no rule against going back to witnesses and rechecking items that are unclear. I think it's very useful to talk to witnesses a couple of times if the dispute is significant enough, because people remember more if you engage them and give them some time. So one of the purposes is to assess strengths and weaknesses of the dispute. I think this is obvious, but it's not a question about being optimistic or pessimistic or liking people or disliking people. We're looking for you to be the objective person to say, what are our strengths and weaknesses? And then I think you got to be ready to address all questions and issues, especially for an agency inquiries. And one of these things to remember is to stay on target. And another film, my third and last film reference, The Lesson from Star Wars, one of my favorite films, where the first film featured Luke Skywalker making the run to shoot a bomb into a small 2-meter portal on the Death Star to destroy it. You know he succeeded. But at the time, he's being fired on by other fighters and guns. R2-D2 is damaged. Darth Vader is after him. Time is running out. In the movie, it's a maelstrom of noise and action, but through it all, you keep hearing, stay on target, stay on target, stay on target. And I think that's important. Never forget your goal here, which is to determine the truth and resolve the dispute. As part of those goals, you're going to have to assess the case and evaluate settlement. So what does that mean? Well, it means that after looking at the materials and having talked to the relevant employees, you take a look at how you can resolve this case. And I think there's kind of 9 informal factors to be considered in making any settlement offer. Number 1, it's the credibility of the student's allegations. Number 2, the strength of the relevant school employees as witnesses. Number 3, the availability and cooperation of relevant former school employees. 4, the amount sought by the student. Number 5, the expected cost of defending the case. And don't forget the time your school employees will expend getting ready, because that time will take them away from their primary tasks. That's a real cost to an institution. 6 is whether the case is an isolated occurrence or part of a larger group of cases. 7, the likelihood that a settlement will encourage other students to assert claims against the school. And the last 2, the likelihood that a settlement will encourage the student's attorney to assert other claims against the school on behalf of other students, and whether the student's attorney is likely to obtain information about other students as discovery proceeds. But there are 9 factors. You could probably list more. You probably have listed more, but it's not a formula. It's important to make a realistic assessment. Don't be afraid to get a sanity check from your lawyer. Once you've decided to settle and have done it, it's over. Don't look back and second-guess yourself. So, last 2 slides, the last 2 things to remember, but I think 2 items that are often overlooked. Timing, speed, and accuracy. Disputes usually don't get better the longer you wait. You got to manage the process and expectations. That's an active thing that you have to do. And you have to manage the complaining student's expectations regarding timing. You are trying to contain this so you get to the end where you can make a decision. And finally, you got to develop actions and act. It's okay to determine mistakes were made. If so, make it right. Don't get drawn into irritations and aggravations of witnesses or management. Don't overreact to your irritation with a student or employee. That's just what life is like. Remember who you are, an educational institution, and always seek the high moral ground. The high moral ground in a dispute is always the best place to be, at least I've found. And so finally, I think overall, remember 3 films really can guide you. Apollo 13, you got to work the problem. Raiders of the Lost Ark, make sure you're digging for information in all the right places. And Star Wars, stay on target. So that's what we have. I'm going to turn it back to Aaron Lacey for questions, and I know we have a few.
Very good. And I'll just real quick, we've got for the CLEers who are still sticking with us, we've got our final poll, which we've got on the screen right now. Click the choice next to freedom below. So there are some bullets. Choose the bullet that is next to freedom. I'm going to go through just lightning fast, a couple 3 resource slides, and then I'll get into the questions. We only have 2 or 3, which is good. That means our presenters answered everything. But we do want to answer the ones that have been asked. So just in terms of quickly the resource slides, we do have our blog. Please feel free to read it anytime. But really, it's our higher education law and policy blog, Recordkeeping. Just a reminder, this presentation will be free on demand, and it's housed on our TCLE. That's a cute combination of Thompson Coburn and CLE. All right, our TCLE website, and you can even see where our notice of proposed rulemaking on bar defense presentation that we did a couple of weeks ago is already sitting there. There are the handsome men who are presenting today, Bill Bay and Jeff Fink. If you have litigation questions, we wanted to include the contact information here. And that's me doing my best impression of a guy who's interviewing for an assistant professor in the English department job. So let's talk about these questions and see if we can get some answers. The first one, Bill and Jeff, how does a school that properly discloses information in writing nonetheless try to protect itself from an allegation that different oral representations were made?
Well, in the end, the best the school can do is by making the disclosures in writing, getting those signed by students, also having the training in place for the employees, having the written policies that govern the employees and that are acknowledged in writing and signed by the employees. Pretty much the best that the school can do, because regardless of what you put in writing, a student can always come back and say, John Doe or Jane Doe told me this. I don't care that I signed something saying just the opposite. I assure you, John Doe told me that. So the best you can do is to develop the record to show that this alleged oral misrepresentation wasn't made and it wasn't relied upon by the student. The best you can do on that is to have the stuff in writing, the disclosures, the training, and the written policies. Because like I said, there's really not much you can do to prevent a student from coming in and making claims of oral misrepresentations regardless of what you've disclosed to him or her in writing. Now, hopefully that would discourage the student from coming in and saying that. Hopefully they'd be too embarrassed to come forward and claim that. But we've seen it in cases we've handled where there were disclosures directly on point saying X, and yet the student comes in and says, well, it was really Y. That's what I was told. And so it's about the best you can do on that.
Yeah, I mean, it doesn't cost any to make a complaint with an agency. It doesn't cost anything to make a complaint with you. I think, the things Jeff's outlined are really protective things. I think they help, but it's not foolproof.
Right.
Yeah, and I'll just add, Bill and Jeff are, of course, litigators. I do some contract drafting, policy drafting. I shouldn't say some, quite a bit for institutions. One thing that I've started doing in recent years, whether it's an enrollment agreement or disclosure or a code of conduct that you might have students sign, some sort of orientation or registration disclosure, I will often include right above the signature block what I call, and I'll label it, student attestation. And I include language that literally says, in signing this document, I represent and affirm that all of the oral representations that were made to me during the enrollment, registration, orientation, whatever you like, process are consistent with the representations that are made in this document in writing. Now, that's not a silver bullet. As Jeff and Bill have said, someone can still allege that some oral representation that was made to them was indeed inconsistent. But, if you're in front of a tribunal or an agency or a jury and you've got a disclosure that has that language right above the student's signature, it does give you a little more leverage in saying, boy, didn't you see that? I mean, when you signed this, you were literally signing right under a disclosure that said the oral representations and written representations were consistent. So it's not a silver bullet, but if you're looking to strengthen some of those written disclosures or agreements with students, that is language you could consider inserting. So the second question really actually I think relates to one of the points that I made. The person has asked, this is back in reference to the false certification discharge that a student can claim if it turns out that due to a medical or physical condition that existed at the time of enrollment, they are unable to satisfy state standards for practice or certification in the field for which the program was preparing them. I know that's a mouthful. But the question is, well, how does that affect the institution in regards to the ADA? And I kind of hinted at this. There's a tension there, right? Because you can't ask questions about disability at the time of enrollment because they can't impact your admissions determination typically. They wouldn't be able to do that under federal or state laws that protect individuals with different types of disabilities, right? So what do you do? What's interesting is the department actually has addressed this. It was sort of buried in some guidance in a rulemaking that came out 2 or 3 years ago, but they confirmed that, yes, for ADA and disability discrimination purposes, you can't ask those questions prior to admission, but there's a distinction between admission and that decision and the financial aid decision. So what you have to do is you have to adhere to those disability discrimination laws that apply at the time of admission. But when you are getting ready to certify a loan, the department indicated in that guidance it would be appropriate to try to, at that time, confirm that an individual could satisfy all of your technical requirements, which if you do anything with disability law, you'll know that's sort of a phrase. Your technical requirements or other requirements for the program or state licensure or certification before you certify that federal financial aid loan. So you could theoretically have a situation where you admit someone, find out about a disability, work out an accommodation plan, but ultimately determine not to certify them for a loan. It is tricky business. If you think you are in that situation, you should consult your counsel. But you're right, there is a tension there, and you have to be mindful of both of those requirements. Okay, let's see. So we've got a nursing school here, Jeff and Bill, that uses a standardized exit exam as a final exam for a course in their curriculum. And they say we require all students to sign an acknowledgement that they received the course syllabus and a requirement, they're acknowledging that they received the course syllabus and they understand the requirement that they have to pass the final exam, and they have to sign that on the first day of class. How sufficient do you think that is to protect the school or provide the school some comfort that someone could not, after the fact, claim that there was a misrepresentation about what all was required?
Well, this is probably about the best way you can handle this situation because, one, you're up front with the student before they start the program that they're going to have to pass the HESI standardized exit exam to graduate from the school. So there's no issue here that you're changing the requirement on the student in midstream. That's the issue we had in the case we had involving another nursing program. It's the nursing program tried to implement a requirement like that after the students had already enrolled. And the fact that you brought it to the student's attention at the beginning, up front, they know they've got to pass this exam, it really precludes the student from later saying, hey, I had no idea that I had to pass this exam when I enrolled. So by disclosing it up front, having them sign an acknowledgement they're going to have to pass this HESI exit exam, it's about the best you can do on this. It's a good practice.
Yeah, and the whole point of using the exit HESI there is because it's supposed to be a good predictor of pass rates on the NCLEX. Having said that, we've had a suit where it was disclosed and somebody sued regardless, and so they ended up getting resolved. But that was one where they said, hey, I didn't need to take it. It's not proper. I knew about it, but it still isn't right. Again, no prohibition on somebody making the complaint because it doesn't cost anything to make a complaint. So you got to deal with it. But I think this is the best protective mechanism.
All right. So last question. We want to close at the bottom of the hour or sooner. Do you see a greater risk to educational institutions from individuals through, say, lawsuits or from regulators? Any comment on the recent resignation of the head of higher education regulation at the CFPB? Maybe take those in part or just answer the first or whatever you like.
Well, I think in terms of the risk, in terms of major risk, you're more likely to face stuff through individual students just because the regulators just don't have the time and resources to go after everybody and to address every student complaint. Now, if the bigger the size and the magnitude of the problem at the school, your bigger risk is going to be with the state's attorneys general because once they get onto you, it can be very difficult to get them off of you. And once they've decided to devote their resources to you, they're going to come at you full bore. So on the one hand, I think your greatest risk in terms is probably going to be from students. as long as you're just having ordinary run-of-the-mill student disputes. But if you let things get out of hand and you start having multiple complaints on the same types of issues, then your biggest risk is going to be through the regulators, and especially the state attorneys general.
Yeah, you're seeing more states that are more active. I mean, obviously what happens nationally may change regarding whose administration there. Jeff alluded to Trump versus Obama and whatever is ahead. But state, that seems to be constant. There are certain attorney generals that have become more active. California's one. There are others as well, and there are challenges that seem to crop up all the time that you got to deal with.
Very good. Hey, I want to thank Jeff and Bill, both of you again today. I want to thank everybody for hanging in, particularly since we went over on time. And just a reminder that just a few weeks away, September 12th, on the other side of Labor Day, we've got our next webinar in our series that's going to focus on mergers and acquisitions in the higher education space. Hope everybody has a great afternoon, a safe Labor Day, and we will see you back here soon.